Leading case 40 Excel. Crop Care Limited v. Competition Commission of India and Another 2017, 5 SCR 901 2017, 8 SCC 47. Did you know that in 2017, the Supreme Court of India ruled on a case involving Excel Crop Care Limited that significantly impacted competition law in the country? This case helped clarify how companies engage with anti-competitive practices. This video provides an in-depth analysis of the landmark case of Excel Crop Care Limited, recent by Competition Commission of India and Another, 2017. A significant judgment that has far-reaching implications on administrative law and public interest litigation in India. Our expert legal analysis delves into the legal principles and constitutional law aspects of the case, highlighting the Supreme Court's ruling on the matter. This case law analysis is essential for law students, legal professionals, and anyone interested in understanding the intricacies of the Indian judiciary and the legal system. The video also touches upon the importance of distance advocacy, civic rights, and judicial education in the context of this case. By examining the legal insights and judicial analysis of this landmark judgment, viewers can gain a deeper understanding of the Evidence Act, Code of Criminal Procedure, and contract law. This case study is a valuable resource for those seeking to understand the Indian Penal Code, cross-examination techniques, and defense counsel strategies in cases involving false allegations, including false rape cases. Hi, I am Advocate Dr. Saurabh Kapoor, bringing you a video on this fascinating topic like this. But before you start watching this video, I request you to kindly subscribe, and hit the bell icon to my YouTube channel. To view videos like this more, please leave a comment below, telling your thought and idea about this video and future videos you want. Introduction. Excel Crop Care Limited v. Competition Commission of India and Another 2017, 5 SCR 901 2017, 8 SCC 47 addresses a significant case in the realm of competition law in India. This judgment dealt with issues of anti-competitive agreements and the jurisdiction of the Competition Commission of India (CCI) over such matters. Facts. Excel Crop Care Limited was alleged to have been involved in anti-competitive practices along with other agrochemical companies. The case centered around a conspiracy to rig bids for tenders floated by the Food Corporation of India (FCI) for the supply of aluminium phosphide tablets used for pest control issues. Raised 1. Whether Excel Crop Care Limited participated in an anti-competitive agreement contrary to the provisions of the Competition Act, 2022, the appropriateness of the penalties imposed by the Competition Commission of India, contention of the parties. Excel Crop Care Limited challenged the findings of the CCI, arguing that the evidence was insufficient to demonstrate participation in any bid rigging or anti-competitive agreements. Competition Commission of India argued that Excel Crop Care Limited, along with other companies, had engaged in a concerted practice that restricted competition, affecting fair pricing in the tenders floated by FCI. Critical analysis of the case. The case critically examines the application of competition law in India, specifically how evidence is assessed in cases of alleged bid rigging. It also highlights the regulatory framework's role in maintaining fair competition in public procurement. Other judgments discussed in the case and their ratio. With citation CCI v. Steel Authority of India Ltd, 2010, 10 SCC 744. The Supreme Court outlined the jurisdiction of the CCI and clarified the procedural aspects related to the appeal process against the orders of the CCI. Excel Crop Care Ltd v. Competition Commission of India, provisions under the Competition Act, emphasizing the need for proportionality and relevance of turnover in determining fines. Opinion of judges. The judges emphasized the need for stringent enforcement of competition laws to prevent anti-competitive practices. They supported the role of the CCI as a watchdog to deter companies from engaging in practices that harm economic efficiency and consumer welfare. Direction. The court directed closer scrutiny of anti-competitive practices, especially in public procurement. It also highlighted the need for penalties to be proportional to the nature and extent of the violation. Finding of the court. The Supreme Court found that Excel Crop Care Limited had indeed participated in an anti-competitive agreement, and that the evidence presented by the CCI was sufficient to substantiate these claims. Final judgment. The judgment upheld the decision of the Competition Commission of India, affirming the penalties imposed on Excel Crop Care Limited and other companies for violating the provisions of the Competition Act. Conclusion: Excel Crop Care Limited v. Competition.